Welcome to Historical Manhwa. I was going through the script late on a Tuesday when I found the move. Not the filing, not the separation, not the phone call at the end. It's a single document request. The third of three, submitted between two things so routine that no one reads it twice. That's it. That's the whole turn. Let me show you how it works. The day they pulled me off partner track, the conference room smelled like stale coffee and someone else's anxiety. Not mine. I had stopped sweating in professional meetings the year I made senior associate. You learn eventually that panic is only useful if you can spend it. Otherwise, it's just noise your body is making in a room where noise is disadvantageous. Mitchell Hargrove sat across from me with his hands flat on the table, the posture of a man who has rehearsed a difficult conversation 2 or 3 times in a mirror and has thus achieved a performance of composure rather than the actual thing. He was 62 years old and had spent 40 of those years constructing, with great care, a reputation for fairness that bore approximately the same relationship to reality as a brochure bears to the place it describes. Vesper. He said my name with the particular inflection of an apology that isn't going to be followed by any change in behavior. You know this decision wasn't made lightly. I looked at him. I said nothing. When men tell you a decision wasn't made lightly, they mean, we made it in about a week, but we felt vaguely conflicted about it during one dinner, and the dinner was long enough that we're counting it as deliberation. The thing about practicing law in the same building for 7 years is that you stop seeing the room. You stop seeing the framed settlement announcements, the diplomas positioned for maximum credential impact, the conference table that was clearly chosen to communicate gravity and succeeds at this the way set decoration in a second-tier film succeeds. You notice it's trying. What you start seeing instead is information. Who's sitting where? Who's making eye contact? Who isn't? Mitchell wasn't looking at me. He was looking at a point approximately 2 inches above my left ear. Dorian was looking at his phone. Dorian Caius, partner, corporate litigation, husband of 7 years. Technically the person in this room who owed me the most, sat at the far end of the conference table with the stillness of a man who has concluded that a decision is final and has therefore removed himself emotionally from the room while keeping his body in it as a courtesy. His phone was tilted at the angle people use when they believe the angle makes what they're doing invisible. It doesn't. Ishasta had watched opposing counsel do exactly this during depositions for 7 years and could read a text thread from 6 feet away if the font was large enough. He wasn't texting anyone. He was reading something, or pretending to read something, which in this context amounted to the same performance. The decision, Mitchell continued, reflects the current strategic priorities of the firm. Which are, I said. The Caldwell acquisition has materially changed our bandwidth requirements across practice groups. We've had to realign several development tracks. Mitchell, I kept my voice level, conversational almost. I've billed over 2,200 hours every year for 6 consecutive years. I have first chair records on 12 matters that closed favorably. So I have client relationships I originated that have brought in, conservatively, $4 million in fees over the past 3 years. I have a performance review, signed by you, dated 4 months ago, containing the phrase, readiness for advancement is not in question. He didn't say anything, so I'd like to understand the specific basis for the decision. He finally looked at me, not warmly, the way partners look at associates who are asking for reasons, which is a thing that partners find structurally uncomfortable because reasons imply accountability, and accountability implies that the decision could have been otherwise. Arabella Cosima will be taking the corporate litigation partner track, he said. The timing reflects firm priorities, not a commentary on your record. I'd like that in writing. Vesper, the basis for the decision. Or send my performance documentation in writing. That's a standard request, and I'd like it processed through document management. He blinked. Once. The way people blink when they've prepared for tears and received something legalistic instead. I picked up my legal pad. I capped my pen. I stood. I'll put the formal request in through the system this afternoon, I said, and I left before he could say anything that would require me to respond. In the hallway, the carpet was exactly as it had always been. A particular shade of charcoal that the firm had chosen because it projected solidity and absorbed stains with equal neutrality. I had walked this hallway 6,000 times. I walked it now the same way, at the same pace, with my face doing nothing in particular. My office was on the 14th floor. The elevator was waiting. I got in, and the doors closed. I stood very still for the ride up. Not from distress. I was taking inventory. The way I take inventory after a difficult deposition, cataloging what had been said and what had been implied, and what the gaps between them were shaped like. Mitchell had not said, "Arabella is more qualified." He had not said, "The decision was performance-based." He had not said anything that could be checked against a fact. He had said, "Strategic priorities, bandwidth, realignment." He had said, "The timing reflects firm priorities." He had said, in the language of a man managing language, "We have made a decision for reasons we are not going to give you, and the decision is that someone else will get what you were promised." And Dorian had looked at his phone. I got out at 14. I went to my office. I did not close the door, as closing the door would have communicated distress. I did not want to communicate distress. I wanted to communicate an attorney continuing to do her work, which was precisely what I was about to do. I sat down. I opened my computer. I navigated to the firm's document management system. I requested 3 things. First, my last 3 annual performance reviews. Second, the partnership criteria document. This was an internal policy document to which all senior associates had a formal right of access under the firm's own operating procedures, a provision that existed because the firm had been sued over a promotion decision 12 years before I arrived and had added it during the settlement. Almost no associate ever asked for it. There was no reason not to ask for it. And my third, the conflict of interest disclosure log for all matters on which Arabella Cosima had billed in the prior 14 months. This third request was the one that mattered, but I submitted it third, quietly, between 2 items that read as routine grievance administration. Not invisible, I was not trying to hide a legitimate document request, and hiding it would have been counterproductive, but unremarkable. A detail in a stack of details. I submitted the request. I pulled up the Greystone receivership file. I continued billing. I had 7 years of practice at waiting. Let me tell you the shape of things before I tell you how they changed, because shapes matter in law and in everything else. I had joined Hargrove 6 years before Arabella Cosima arrived, straight from a clerkship that had been good enough to give me options and specific enough that I'd chosen corporate litigation with intention rather than default. I had understood early what the firm valued, which was billable hours, client retention, and the appearance of institutional coherence in roughly that order. And I had made myself useful in each category with the kind of quiet efficiency that earns genuine respect from the people doing the actual work and occasional resentment from the people who prefer a noisier version of ambition. I had also, 3 years in, married Dorian. I want to be precise about this. Dorian Caius was not a bad man when we married. He was a careful man, methodical, ambitious in a structured way, good with strategy. He made decisions by identifying what he wanted, and then constructing the reasoning that would lead to it from first principles until the reasoning appeared to be where the decision had originated. He was very good at this. It had made him an excellent litigator. It had made him, I had thought, an honest partner. What I had underestimated, what you underestimate when you marry someone who is good at constructing arguments, is that the same mechanism works on the person they love as smoothly as it works on anyone else. Maybe more smoothly, because the person they love has let down certain guards. Arabella arrived in November. She had come from a smaller boutique firm where she'd made noise on a securities matter that got picked up by a trade publication. Dorian had hired her. He mentioned it over dinner as a passing administrative note. New associate on the corporate team, sharp, good instincts on the Caldwell structure. He said her name once and passed the breadbasket, and we talked about other things. I registered it and moved on. By February, the calibrations had started. They were small, late returns on Thursdays. Not every Thursday, but some. A phone that had always lived face up on the kitchen counter beginning to arrive face down. A shift in the vocabulary he brought home from the office. Arabella had an interesting read on the indemnification structure. Arabella flagged a precedent I'd missed on the regulatory piece. He said her name the way people say the name of a person whose judgment they've started to need, with a slight uptick at the beginning, as if the name itself were interesting. I noticed all of this. I noted none of it, because noting requires a theory. Oh, and I was still in the phase of collecting data without yet having committed to a conclusion. I was also working 16-hour days on the Greystone receivership, which Dorian had described as incredibly important, in a tone that managed to convey both the importance and the implication that importance of this kind was not the glamorous sort. The Greystone matter was complex, technical, and not the kind of work that generated client dinners or visibility. It was the kind of work that gets done quietly and comes out right, which is a kind of work that only gets credited in full by people who understand what it is to do it. By the time I sat across from Mitchell in that conference room, it had been 6 weeks since I had last attended a firm event. Arabella had been at 3 in that period. The conference room meeting, in the end, did not surprise me. What interested me was how clean it was. The choice of language, the positioning of Dorian at the end of the table, present and uninvolved, a simultaneous witness and alibi. Someone had thought through the architecture of that meeting. And it hadn't been Mitchell, whose particular skill in difficult conversations was surviving them, not designing them. The documents arrived over 3 days. My performance reviews, consistently excellent over all 3 years, with specific notation in the most recent cycle about my management of the Greystone matter and my readiness for advancement, language that made the decision in the conference room look less like a promotion decision and more like a correction to something already decided elsewhere. The partnership criteria document, standard, nothing surprising, containing the categories any attorney on a serious track would expect: client development, matter leadership, firm contribution, and mentorship, with no new provisions that would explain why a different candidate had been selected. The conflict of interest disclosure log was more interesting. Under the rules of professional conduct, specifically Rule 1.7, which governs conflicts of interest in simultaneous client representation, as adopted in our state bar, an attorney is required to identify and disclose any material conflict, obtain informed written consent from all affected clients, and maintain that consent documentation in the matter file. This is not an aspirational standard. It is a mandatory process step, and the absence of the documentation is itself a finding. Arabella had billed on 4 matters in the prior 14 months. 2 of those matters involved Caldwell subsidiaries. One of those matters was directly adverse, on a federal regulatory question, to a client that Hargrove had represented continuously for 11 years, and for whom I was still technically the relationship attorney of record. The client was Windmore Capital, led by its CFO, Roderick Wendmore, a careful and precise man who had chosen our firm specifically because he valued consistency in his outside counsel relationships. The conflict between Arabella's Caldwell work and the Windmore representation should have been identified at intake, disclosed to both clients, and resolved with written informed consent, or by declining one of the representations. The consent form should have been in the file. It was not in the file. I read this 3 times, not from excitement, but from precision. I needed to be certain I was reading an absence and not a misfiling. I cross-referenced against 2 related matter files. The consent documentation was not in any of them. I went back to my computer. I navigated away from the document management system. I opened, on my personal laptop, an encrypted portable drive I had set up 4 years earlier during the Meridian litigation, when I had learned what it meant to lose documentation. It was organized by matter and date, backed up to a separate location weekly. Entirely normal practice for a careful attorney. Utterly unremarkable if anyone were to ask about it. I created a new folder. I labeled it Professional Observations. I put nothing in it yet. I noted only what I was now looking for. Let me tell you about Arabella precisely, because she deserves precision. She was talented. I want to say this cleanly without performing graciousness. She was genuinely skilled. A fast reader, numerically fluent, strong on deal structure, with the particular confidence of someone who arrived knowing she was going to be useful and was correct about this. In a different version of this story, in a firm where the architecture was different and the incentives ran differently, I might have worked alongside her productively. I might have valued her. In this version, she had made herself the mechanism of a decision she was at minimum aware of, and at most had actively participated in shaping. And she had done so with enough awareness to make her culpable rather than incidental. I knew this because of what happened in the elevator, 3 weeks after the conference room. I was going down to the parking structure. Arabella got in at 14. We were alone for 7 floors, which is long enough for a conversation, but short enough that neither party can be expected to commit to one. She said, very precisely and without preamble, "I hope there are no hard feelings, Vesper." Hard feelings, as though we'd lost the same game, as though the circumstance had been symmetrical. "Of course not," I said. She smiled. It was the smile of someone who had anticipated relief and found neutrality instead, and wasn't quite sure what to do with neutrality because it didn't perform the absolution she was after. The elevator opened, she stepped out, the doors closed. I continued to the parking level. In my car, I sat before starting the engine. What she had said was specific. She had not said, "I'm sorry you were passed over." She had not said, "I hope we can work together going forward." She had said, "I hope there are no hard feelings," which is the language of someone who knows there are grounds for hard feelings, who wants the grounds acknowledged and then dissolved, and who has decided that asking for this absolution obliquely is somehow more comfortable than asking for it directly. It was the language of someone who had done something she couldn't quite name in polite company but needed forgiven anyway. I drove home. I did not mention it to Dorian. In the weeks that followed the conference room, I continued working. The Greystone receivership was entering its final complex stage, the part where the administrative details compound, and the exit requires a level of attention that most attorneys are not willing to give a matter that has already stopped feeling interesting. I gave it everything because the client deserved everything, and because I am constitutionally incapable of doing work at less than full capacity regardless of what is happening around it. I also began keeping the log. Not a diary, not a journal, an attorney's professional observation log, dated, time-stamped, factual, stripped of adjectives and editorial comment, in the way that documents intended for potential future use must be stripped, so that their content is factual record rather than opinion. So now I had seen too many attorney diary entries weaponized in proceedings, the I felt and I noticed language that opposing counsel turns into a credibility argument, to make that mistake. What I was logging was pattern, not feeling. What the pattern showed over the first 2 months. Arabella was billing strategy hours on matters that hadn't crossed the authorization threshold that would require partner supervision, which meant the hours were either inflated beyond what had actually been performed, or they reflected work that hadn't been sanctioned. I found 3 instances of this in the billing records, which were accessible to me through the firm's system, because I had active billing codes on related matters and could view the broader matter structures. I did not access anything I was not entitled to access. This is important. Every document I reviewed was accessible to me under the firm's own internal policies and my active billing status. I did not look for what I wasn't entitled to feed. I found what was already visible to anyone looking with the right knowledge of what visible things meant. The second pattern was more significant. A client communication had gone out under Arabella's name on a matter that still listed me as relationship attorney. The communication had not been copied to me. Roderick Wenmore, CFO, careful man, precise in all things, had called my cell phone, which he had used reliably for 4 years, to ask a follow-up question on the advice he'd received. He was, he explained mildly, slightly confused about the new arrangement. I told him I'd look into it. Then I sent him a considered email. Could he tell me what communication he'd received and whether any questions had been left unanswered? His response arrived the following morning, with a forwarded copy of the email Arabella had sent him, advisory in nature on a regulatory question, and a note saying he'd understood from the email that I had been consulted. I had not been consulted. I printed the email chain. I added it to the professional observations folder with a date stamp and a 1-line note. Communication sent to Winmore Capital client by A. Cosima without relationship attorney authorization. Client understood authorized approval to exist. 22 words, no adjectives. 6 weeks later, Dorian told me he was in love with Arabella. He did this in the kitchen on a Wednesday evening while I was reading a brief at the counter. He delivered it with the careful deliberateness of a man who had been carrying a prepared speech for a while and had finally decided the carrying was worse than the delivering. He loved me. He had always loved me. Something had shifted. He owed me honesty. I put the brief down. I looked at him. He had the expression of a man who is prepared for tears and is vaguely unnerved by their absence. "Thank you for telling me," I said. A pause. That's it? What would you like me to say, Dorian? He ran a hand across his face, the gesture of a man encountering something that doesn't map onto his expectations. Vesper, you're allowed to. You've made a decision, I said. You've explained it. I'm not going to perform a reaction for your benefit. He left the kitchen. I heard him in the study for a while, and I returned to the brief. My hands were steady. I note this not for drama, but for accuracy. My hands were completely steady because I had known this was coming for approximately 4 months. I had processed it in increments, in the quiet of nights when the shape of things had made the conclusion legible even before the words arrived. By the time he said it in the kitchen, it was not news. It was the formal notification of a thing I had already made peace with, in small pieces, over a long time. I had also, 3 weeks prior, transferred my personal investment accounts to a new management firm. The accounts were mine. I had maintained them separately since before the marriage. As a matter of financial hygiene, I had always considered non-negotiable. And the transfer was a routine administrative act. And I had had a conversation with a matrimonial attorney at a retirement dinner for a colleague. Just conversationally, just a professional being informed. The professional observations folder grew through autumn. By October, it contained 6 documented instances of potential rules violations, indexed by rule number and calendar date. 2 instances of billing anomalies, the Windmore communication chain, the conflict of interest log showing the absent consent documentation, a note about Arabella's statement in the elevator, included not as evidence of anything but as chronological context. 6 instances was a pattern, 6 instances documented over 7 months, with third-party material from an affected client, constituted what the bar's disciplinary manual describes as a substantial record warranting inquiry. I needed one more thing to make the record unambiguous. I did not have to look for it. It arrived because the original problem, Arabella advising Roderick without proper authorization on a question she was not qualified under firm protocols to advise on alone, had consequences, and consequences have a way of surfacing regardless of whether anyone is actively looking for them. In the 2nd week of October, Roderick called me directly. He was calm. Roderick was always calm. It was one of the things I genuinely respected about him. Having worked with many clients who confused volume with urgency and had found his consistent precision a professional relief. He explained that the regulatory position Arabella had advised him on had turned out to be materially incorrect. Not catastrophically, the matter was recoverable, but incorrect in a way that had caused him to take a position in a regulatory filing that now required amendment. The amendment would require disclosure to the agency of the position change and a supplemental explanation. He was not angry. He was asking for my help. Roderick, I said, before we talk about the amendment, can you tell me exactly what you understood about Arabella's authorization when she sent you that analysis? I understood, he said without hesitation, that you had reviewed it. She mentioned your name in the email. Something to the effect that the analysis was consistent with our ongoing strategy. I assumed that meant your sign-off. I asked him whether he'd be willing to put that in writing. A simple letter, what he had understood, what representation had been made, what he had relied upon. He said yes without hesitation. He was a precise man, and he understood what accurate documentation was for. The letter arrived the following morning on company letterhead. I read it once. I placed it at the front of the Professional Observations folder and reorganized the folder into a formal chronological index. The folder was now 26 pages. It had a cover sheet, a table of contents, and exhibits labeled by letter. Here is the mechanism, because the mechanism is the point, and I want to be clear about it. Every attorney in this country is licensed by a state bar. Every state bar has a disciplinary arm, variously called the Office of Disciplinary Counsel, the Attorney Grievance Commission, the Disciplinary Board, depending on the jurisdiction. These offices receive complaints from clients, opposing counsel, third parties, and from other attorneys who have direct personal knowledge of violations. The bar takes complaints from competing colleagues with appropriate skepticism. A single complaint, filed by someone with an obvious professional interest in the subject's downfall, filed at a moment of obvious personal tension, will be reviewed carefully and may result in a minor finding or no action at all. Grievance offices have seen the disgruntled competitor story enough times to recognize its shape and treat it accordingly. What the bar cannot credibly set aside is a documented pattern. A complaint that spans 7 months of dated records, that includes third-party client documentation, that references specific rule provisions with numbered subsections, that identifies actual client harm with the client's own signed letter describing what representation was made and what reliance followed. This is not a grievance. This is a record. The 3 rules I had documented evidence against were Rule 1.7, conflict of interest in simultaneous representation, the Caldwell-Winmore conflict with the absent consent documentation, Rule 1.4, communication, the unauthorized communication sent to Roderick without my knowledge or consent on a matter I still held, Rule 8.4, C, misconduct involving dishonesty, fraud, deceit, or misrepresentation. This was the provision that required the most careful support, because it requires not negligence, but an affirmative act of dishonesty. Arabella had mentioned my name in her communication to Roderick in a way that caused him to believe my authority stood behind her analysis. That was not an oversight. That was a choice. The 8.4C charge, if it held, was the one that ended licenses. On the 14th of November, I submitted a formal complaint to the Office of Disciplinary Counsel through the bar's secure online portal. The complaint was 34 pages, organized with an index, exhibits labeled A through R, a timeline graphic, and a 1-page summary at the front identifying the 3 specific rules at issue. I received a confirmation number within 20 minutes of submission. I went to bed. This is the part that people find strange. Not that I filed, but what I did afterward. I went to bed at a reasonable hour and I slept adequately. But the work was finished. Finished work is how I sleep. I don't need ceremony around closed files. I filed for legal separation in November, 2 weeks after the complaint. Dorian was not surprised. We had a conversation that lasted 12 minutes and covered the practical arrangements. I had already spoken with a matrimonial attorney. He agreed to retain separate counsel. He said he wouldn't contest the financial structure. He said at the end of the conversation, in a tone that was trying to be neutral but wasn't quite, "You've been thinking about this for a while." "I've been considering my options," I said. "That's different from planning." He almost smiled. "Vesper? Is it?" I picked up my bag. I left. My separate apartment, a 2-bedroom in a building across the city, leased 4 months prior under my own name, furnished over several months of evenings I had described to Dorian as working late, which was not entirely a lie because I always brought a brief, had by then the particular comfort of a space organized entirely by one person's preferences, which is a specific kind of comfort I recommend. The bar investigation began in December. An attorney I know professionally, Gideon Prosper, a disciplinary attorney I had met at a bar conference 3 years before and maintained collegial contact with, mentioned in conversation, without identifying any parties and without impropriety, that a new matter had come into the ODC that was generating some procedural interest among the disciplinary attorneys. He mentioned it as a professional weather note. He said nothing specific. He said nothing he wasn't entitled to say. I said nothing back. And I listened and continued drinking my coffee and asked about his daughter's semester abroad. At the firm in January, I was reassigned. The move was presented as an opportunity, realignment toward dispute resolution, a growing practice group, a chance to develop a complementary skill set. The language was careful and not accidentally so. What the reassignment actually was, a reduction in my visibility with corporate clients and a removal from the matter work that would have supported a partner application. I accepted the reassignment without comment. Within the week, I reached out directly, by phone, which leaves no firm record, which was intentional, to 3 of my key client relationships, including Roderick. The conversations were brief and professional. I wanted them to know I remained available to their matters, that my representation was unchanged, and that I would be happy to discuss continuity arrangements if any transitions were anticipated. 2 of them said they would follow me if I were to move. I opened a new folder, not the professional observations folder, a folder labeled Next Position. In February, the bar issued a formal document request to the firm. I know this because Mitchell Hargrove called me into his office, the good office, the one with the view where the serious conversations happened, and asked me, with barely managed composure dressed as conversational tone, whether I had any awareness of a disciplinary inquiry touching certain matters. I looked at him. "Should I?" I said. A long pause. A careful pause. The pause of a man deciding whether the next sentence could be used against him. "No," he said. "Oh, of course not." "Then I'm not sure what you're asking." I left his office. That evening I sent Gideon a note. "Any interesting matters lately?" He wrote back a single line, one that's developing faster than the standard timeline would predict. I read it once and closed the email. In March, I received a lateral offer from a firm I had been quietly in conversation with since January. A smaller firm, leaner, with a culture that could be described as functional meritocracy in the sense that the people who made partner were the people who brought in work and did it well, without the additional criteria of whose table they sat at or which conferences they attended. I had been approached by their head of corporate through a mutual contact, had agreed to a conversation, and the conversation had developed steadily. In March, as the formal offer arrived, the offer included a salary that reflected my actual market value, which Hargrove had been paying below for 2 years by then, a path to partnership with specific, written criteria, discussed honestly and confirmed in the offer letter, and a provision, negotiated carefully, with the firm's knowledge over 2 weeks, that 2 of my existing client relationships could transfer with me, subject to standard client consent protocols. I accepted on a Thursday. I gave standard notice the following Monday. At my departure from Hargrove, I thanked Mitchell briefly for the professional development I had genuinely received at the firm, because the gratitude was genuine, even if the rest of the experience had been what it had been. And inaccurate farewell speeches are a bad habit I've never cultivated. I cleaned my office over a weekend. I departed on a Tuesday morning, nodded to the receptionist who had always been kind to me, and took the elevator down for the last time. In the lobby, I walked out through the revolving door into the open air, which smelled like the particular combination of exhaust and cold November concrete that I had always associated with arriving somewhere. I flagged a car and went to my new office. The formal charges against Arabella Kozima were filed by the Office of Disciplinary Counsel in June. I learned about this through a legal news brief that Roderick forwarded, the kind of daily roundup email that circulates through the corporate general counsel community. No, the one that collects bar notices and disciplinary announcements, because people who hire outside counsel find this information professionally relevant. The brief was 3 sentences. Arabella Kozima, formerly of Hargrove, subject to formal disciplinary charges on multiple counts under the Rules of Professional Conduct. The specific rules cited 1.7, 1.4, and 8.4c. 8.4c was there. I noted that and set the brief aside. The 8.4c charge anchored on the Windmore communication, the email in which Arabella had implied my authorization, which had caused a client to rely on incorrect advice, which had caused an amended regulatory filing. The misrepresentation was documented with the client's own letter, time-stamped against the original communication, against the billing records, against the conflict log. Let's hope the bar does not like patterns that look like decisions. They had a pattern that looked like several decisions. In September, a formal hearing panel convened. I was not a party. I was a documented complainant and listed witness. I submitted a witness statement in July, 14 pages, chronological, organized the same way the original complaint had been organized, with exhibits relabeled to correspond to the formal charge numbering. The statement contained no adjectives. It contained dates, documents, and the facts those documents established. Gideon, over coffee in early September, said, with the careful precision of a person who chooses every word, "When the third-party reliance letter is that specific, and the billing patterns are what they apparently are, the narrative of oversight becomes difficult to maintain before a panel." I nodded. I asked about his daughter's gap year. I drank my coffee. The bar panel issued its decision in October. Arabella Kozima was disbarred. The primary finding was under Rule 8.4. C. The misrepresentation to a client, the implied authorization she had never held, the advice that had been followed and proved incorrect and had caused actual harm to an actual matter. The secondary findings on Rule 1.7 and Rule 1.4 provided the pattern context that made the primary finding a conclusion about character rather than an isolated incident. She could apply for reinstatement after 5 years. That is the process. I mention it because accuracy requires mentioning it, and because whether she does or doesn't is genuinely not a consideration I hold. Dorian called me in November. He said he was calling to check in. He'd heard the transition to the new firm was going well. He'd heard the Windmore relationship had come with me. I said the transition was going well. A pause. Arabella's... He stopped. It's been difficult. She's filing an appeal? I know, I said. Another pause. The longer kind, the kind that means the next sentence has been prepared and the person is deciding whether to deliver it. Vesper, did you... He stopped again. Then, were you involved in the complaint? Dorian. I kept my voice very even. I made a report to the relevant regulatory authority documenting violations of the rules of professional conduct over a period of 7 months, supported by third-party client documentation and firm records I was entitled to access. That is a thing any attorney can do. It is arguably a thing any attorney who has documented knowledge of violations has an obligation to do. A long silence. Is there anything else? I said. He said there wasn't. We ended the call. I put the phone face down on the desk. Not for effect. Only because I was done with it, and the brief in front of me required both hands and my full attention. The Greystone receivership finalized in December. The client, who had transferred with me without drama, because they had wanted to work with me specifically and had made that clear, sent a bottle of good wine and a handwritten note on their company stationery. The note said that in 30 years of engaging outside counsel on complex matters, they had found that what distinguished the exceptional attorneys from the merely excellent ones was a particular quality of attention in the room when the matter became genuinely difficult, a quality they believed I had demonstrated consistently throughout the Greystone work. I read the note twice. I set it on my desk, in the corner where it would be visible from where I sat, and returned to the restructuring pitch I was drafting. The partnership vote came in March. 1 month ahead of the 18-month timeline discussed at the offer stage, the vote was unanimous. My book of business had grown, in 11 months, to a size that made the outcome a fairly uncomplicated calculation. Roderick Windmore had recommended me to 2 CFOs in his network. The quiet, a specific recommendation of a satisfied client who decides that a good attorney is a thing he wants other people to have access to, and both had become active relationships. I had not asked him to do this. He had done it because when his regulatory filing needed to be corrected, I had handled the correction cleanly and competently and had not made the episode about anything other than the client's best outcome. That is, ultimately, the entire job. Hargrove sent a formal congratulatory note, which I found instructive as an artifact of how quickly institutional positions reorganize once the internal facts have changed. I sent back a brief collegial response. Warm enough to be professionally appropriate, short enough to communicate that the warmth was professional. On my last evening before the official partnership start date, and I sat in my office after the floor had emptied and reviewed the following day's matter list, which is the thing I have done at the end of every working day for 7 years because it is the most efficient way to begin the next day clear. Nothing had been missed. I sat for a moment in the office with the lamp on and the city visible through the glass behind me. The city at night has a particular quality. The distance between lit windows, the suggestion of hundreds of parallel rooms in which hundreds of parallel lives are at various stages of their various decisions. I find this neither comforting nor disconcerting. It is simply the view. I thought about the conference room, the coffee smell, Mitchell's hands flat on the table, Dorian looking at his phone. I thought about the elevator. I hope there are no hard feelings. And I thought about a Tuesday afternoon when I had submitted a document request, 3 items, the third of which was the one that mattered, filed quietly between 2 routine things, and received without particular attention because it looked like an attorney managing her paperwork. That was the move. It was not dramatic. It was not even unusual. It was an attorney using a system she was entitled to use, to access information she was entitled to access, because she was paying close enough attention to know what the information meant. The story proceeds from there in the only direction available to it, once you have the information and the patience to let it develop to its natural conclusion. I turned off the lamp. I picked up my bag. I walked to the elevator. The corridor lights cut out behind me automatically, section by section as I moved. The elevator opened. I got in, the doors closed. The building's hum, the HVAC, the low electrical current, the particular frequency of a building occupied by people who are all working very hard toward various outcomes, settled around me for the ride down. In the lobby, the night security guard said, "Good night, Ms. Vesper." "Good night," I said. I went home.